Running a startup business means 24/7 over several years. It also means to challenge your business decisions almost every day. And it's much easier doing so within a team and a partnership with other co-founders. Hi, my name is Philipp Kinsky. I'm one of the founders and partner at Kinsky Attorneys at Law. We at Kinsky are focusing on innovative business models and fast-growing companies, and are mainly active in transaction services like M&A, venture capital, and capital markets. While ideas cannot be protected under Austrian law, there are other intellectual property rights that are eligible to be protected, like inventions, copyrights, designs, trademarks, and domains. Any involvement of co-founders, students, freelancers, trainees, or other third parties could lead to joint ownership of IP in case they contribute to the IP of the company in an early stage of the company. By securing this IP, you guarantee the ownership of the IP for the company, and it becomes very important, especially in later stages in financing rounds and exits, where founders usually have to guarantee and represent and warrant the ownership and unlimited rights with respect to the company's IP. Running a startup business means 24/7 over several years. It also means to challenge your business decisions almost every day. And it's much easier doing so within a team and a partnership with other co-founders. So it becomes very important in a very early stage of the company to select the right co-founders. The selection of co-founders is mainly driven by personal expectations as regards commitment and skills. While some of the founders believe that they should be rewarded for the past, in most of the cases, founders believe commitment in the future. And these commitments are usually mirrored in vesting schemes, which provides for rules and regulations and the rights of the other founders to acquire shares of a leaving founder in case he leaves the company prematurely. In case those vesting schemes and legal arrangements are not in place, it becomes very difficult to convince or even acquire shares of a leaving founder in a later stage of the company. Those legal arrangements are not only entered into to penalize a leaving founder, but more important, to substitute the know-how and the knowledge of the leaving founder and to have a certain consideration in place for any future co-founder which enters or exceeds the company in a later stage. If you do not enter into these vesting schemes from the very beginning, any transfer of shares in a later stage could trigger tax payments, not only for the selling founder, which sells the shares at the price which is higher than the initial purchase price, but also for the acquiring founder, which receives those shares at the purchase price which is lower than the market value. Once you have selected the right legal form, it becomes very important to draft the foundation documentation in a way which meets your personal needs and the needs of your business model. Articles of a biotech company or a medtech company usually look different than articles of a SaaS or a platform company. Why? Because the financial requirements to become break-even is much higher, and founders usually become minority shareholders with biotech or medtech companies in a much earlier phase of the life cycle of the company. So while founders within a biotech company or a medtech company should focus on minority rights, as they would be a minority shareholder when it comes to exit discussions, founders of SaaS companies or platform companies usually are still in a driver's seat in an exit event and remain a majority shareholder for a longer period in time. Do your investors' research in a proper way. So talk to as many other founders about the know-how, the track record of the investor, the size of investment the investors are usually investing, whether they are investing in follow-up financing rounds, talk about their private situations, whether they have certain exit pressures, talk about their network, and whatever is helpful to get full information of the investor. If you collect smaller tickets, appoint one of the investors acting as a lead investor and as a trustee for the other investors. It would keep the cap table of the company very lean, and it would also meet the expectations of institutional investors. Appoint a team member who is in charge of coordinating the round. Be aware of the cash out date. Usually takes much longer than expected, and you won't get a second chance to restart the process once an investor refuses to invest into your company. Don't start the investor search too early. It's very important to hit milestones first, because milestones are the driver for valuation, and higher valuation means less of dilution for the founders. It's much easier to convince investors to invest into your company when certain milestones like proof of concept or first revenues have already been gained in the market. Never tell an investor too early who else you're talking to. Try to enter into a term sheet with the lead investor and then provide the other investors with a closed window of opportunity to co-invest into the company. Numbers are getting more and more important, so be prepared to provide investors with a reasonable budget and a reasonable business plan. Try to onboard the key investor from the very beginning and have these key investors presented your startup to other co-investors. Co-investor pitches are much easier than presenting in front of the whole investors crowd. Keep the term sheet as simple as possible. If you enter into term sheet discussions with investors, it depends to whom you're talking to. Business angels usually expect a term sheet being provided by the founders, while investors and venture capital and institutional investors have their own term sheets with their own terms, and they will provide you with a first draft. Try to negotiate these term sheets very diligently. Even they are non-binding, it would result in a breach of trust between the founders and the investors if you start renegotiating those term sheets after you have executed it. Those term sheets usually include almost all material provisions regarding the operations of the company, exit-related rights, and certain preferred rights granted to the investors. When it comes to valuation discussions, don't be too bullish, because investors will challenge you in different ways. They would probably include a down round protection, a liquidation preference, or even milestones payments, where they contribute the main portion of the investment upon fulfillment of certain milestones and in tranches. And in certain cases, they would even force you to present the validity and correctness and plausibility of the business plan. And I have one bonus tip for you. Talk to as many other founders as you can. Ask as many questions as you can. If you share information, if you share knowledge and experience, you are better prepared for almost all business decisions in the future.